Hey guys, welcome to the first video that we've done in our new office. You see I got my brick wall behind me in the office here, and I'm ready to get going on our segments of our legal update. We're going to be doing several videos talking about the legal updates for 2021, and we'll piece it out and compile it over time. The first update today is going to be regarding the notice of late assessments and the change of the demand letters from 30 days to 45 days. All of the demand letters now, your intent to lien, your intent to foreclose, all have to be 45 days. Obviously, they've been that way for HOAs for a long time, and the condo letters were 30 days, and so are the cooperative letters. Now they're all 45 days. So it makes it easier for training your managers. I don't think this is going to change the time frame to get things much done. Obviously, it's going to delay things by a couple of weeks, but as a practical matter, if you stay on top of things and send the demand letters out in a timely manner, it's really not going to adversely affect the associations, and having the consistency between the HOA Act and the Condo Act on the whole, I think, is a good thing. Now, the question that I've been getting about this is, what if you're midway through the collection process? And my opinion is that whatever you've done before the effective date of the statute, which was July 1, is fine. So if you've sent out your intent to lien letter before July 1 and you have filed your lien before July 1, then I think your intent to foreclose letter and your everything else needs to be pursuant to the new act, but the new section of the Condo Act. If you've already done your intent to lien and intent to foreclose, then I think you're okay with that too. If you did that before July 1st. If you haven't done it, or specifically if you haven't finished the intent to lien notice, so say you're in that time frame right now. Say you sent the letter out June 15th. New statute became effective July 1st. If you haven't filed the lien yet, I'd probably send a new intent to foreclose. It's a very small cost to remove any doubt of proper notice, and you can clean it up that way. But that leads into the next thing, is this new notice of late assessment. Now, the law requires for condos, HOAs, and co-ops that you send out a notice of late assessment, which is like a really formal demand letter that goes before the intent to lien letter. This letter gives that owner that one last opportunity to pay before the legal fees get incurred. And specifically, the statute says the letter should include assessments, late fees, interest, and that's it. Now, the that's it part is my commentary. The statute does specifically say that the association cannot levy attorney's fees prior to the expiration of that 30-day notice of late assessment letter being sent out, or the 30 days having passed. Now, what it doesn't say is, what about these management collection fees or coordination fees or whatever you have on there? It's silent on that issue. My advice to clients is I would really try to stay away from charging those fees. In my opinion, the policy from the legislature is we want to try to give owners one more chance without any collection costs or attorney's fees or whatever else, just the pure assessments, late fees if you're authorized, and interest. Let them know this is for real, your last chance to pay, and if you don't, at that point you can start incurring collection charges. So most of my associations, really this is just replacing that sort of second, more formal demand letter before it gets sent over to the attorney. The vast majority of my associations usually send out one courtesy late notice saying, hey owner, I think you may have forgot to pay your assessments. Then there's another letter that goes out that says, now you're late, you need to pay this before we turn this over to collections. That this new notice of late assessment letter replaces that one. Then once that 30 days is up and they don't pay that, that's when it usually gets kicked over to the attorney to send the intent to lien letter. So make sure you put that in with your processes. Make sure your managers are trained that now condominiums have to provide 45 days notice for your intent to lien and your intent to foreclose letters, and there will be more updates coming soon. Thanks, guys.